5 seconds to go. Start. Thereafter, even notification under Section 16(2) of the Land Acquisition Act 1894 was also issued, vesting the suit land absolutely with BDA, and thereafter collusively and or illegally respondent number 1 herein entered into agreement of lease with respondent number 2 herein. It is submitted that as such, in the present case, even the substantive suit filed by BDA being OS number 2070 of 2013 to declare the agreement of lease between the decree holder and judgment debtor is null and void is pending. It is submitted that therefore the executing court ought to have allowed the impleadment application filed by BDA who claims the title on the basis of the acquisition of the land under the 1976 Act. It is further submitted that Order 21, Rule 97 and Rule 101 CPC are to be read together. It is submitted that as per Order 21, Rule 101, all questions including questions relating to right, title or interest in the property arising between the parties to a proceeding on an application under Order 21, Rule 97 or Rule 99 or their representatives and relevant to the adjudication of the application shall be determined by the executing court dealing with the applications. It is further submitted that while raising an obstruction objection to the execution of the decree, the obstructor need not prove its possession, but when it claims right, title or interest in the suit property, the same is required to be determined, decided and or adjudicated upon by the executing court in such an application. Making the above submissions, it is prayed to allow the present appeals. Learned counsel appearing on behalf of the respondents have tried to support the orders passed by the High Court as well as the executing court. It is submitted that according to the decree holder, original landowner, the actual possession of the land in question has not been taken over by BDA and the possession of the land in question is with the judgment debtor respondent number 2 herein, which is required to be handed over to respondent number 1 herein decree holder pursuant to the judgment passed by the High Court. It is submitted that the executing court rightly rejected the applications filed by BDA under Order 21, Rule 97 CPC. It is submitted that as rightly observed by the executing court and confirmed by the High Court that though the land in question might have been acquired unless and until the possession by the obstructionist is established and proved, such an application under Order 21, Rule 97 CPC is liable to be dismissed, and the same was rightly dismissed by the executing court and is rightly confirmed by the High Court. We have heard the learned counsel for the respective parties at length. At the outset, it is required to be noted that the BDA is claiming right, title or interest in the land in question being acquired under the provisions of the 1976 Act. It is required to be noted that the lease agreement between the decree holder and the judgment debtor is subsequent to the acquisition of the suit land. Therefore, it is the case on behalf of the appellant BDA that such a transaction is null and void once the suit land for which the lease agreement was executed was acquired under the provisions of the 1976 Act. Moreover, the award was also declared and a notification under Section 16(2) of the Land Acquisition Act evidencing taking over possession of the land by BDA was also published. Therefore, when the appellant BDA, which had submitted the obstruction objection in the execution proceedings filed by the decree holder against the judgment debtor with respect to suit land which was acquired by BDA, and when the BDA claims right title or interest in the suit property, such obstruction objection was required to be adjudicated upon by the executing court while considering the application obstruction under Order 21, Rule 97 or Rule 99 CPC. At this stage, Order 21, Rule 97 and Order 21, Rule 101 CPC are required to be referred to and which read as under. Stop.